Welcome everybody to this very exciting event. Let me begin by acknowledging that we meet on the lands of the Wurundjeri peoples of the Kulin Nations. We pay respects to elders past, present and emerging, and note particularly the importance of the Academy for Indigenous knowledge. So Indigenous knowledge contributed to the Academy before we had a formal Academy, and so it is appropriate that we pay those respects, particularly in the context, I think, of today's talk on climate justice and insurgent lawyering in the ICJ and beyond. I'm very excited to be welcoming our speakers. Let me briefly introduce them. We have Alofipo Fleur Ramsay, who is visiting Professor of Practice at Birkbeck Law School, the University of London, and an international Indigenous and human rights lawyer at Blue Ocean Law in Guam. Blue Ocean Law represented Vanuatu and the Melanesian Spearhead Group at the International Court of Justice in the advisory opinion proceedings on climate obligations. And Fleur has also acted as co-counsel for Samoa in those proceedings. She's also been a Winston Churchill Fellow. That fellowship was awarded for her to travel and research innovative lawyering and best practice Indigenous environmental law and practice. And she has been a solicitor, a barrister, and a judge's associate at the Federal Court, and is also completing doctoral studies on the notion of prohibition and taboo, which is very exciting and has some very interesting intersections with today's topics. I'm also delighted to be welcoming Professor Stewart Motha, Professor of Law and co-director of the Centre for Law and Humanities at Birkbeck College, University of London. His most recent monograph is Archiving Sovereignty, Law, History, Violence, which was published by University of Michigan Press in 2018. And you might also know him from his regular podcast, Countersign, which I encourage you to subscribe to. I also have to give apologies from Dylan Asafo, who was due to chair this session, but he's overseas at a climate lawyering workshop. He harks from Samoa and New Zealand. He appeared in the Cook Islands for the Cook Islands in the ICJ case. He's also currently completing a PhD here at the Melbourne Law School, supervised by Professor Sandhya Pahuja, who is here, and me. And he would have loved to be here, so we'll miss him, and I'm chairing in his absence. So the format of today is that I will give a quick overview, very brief overview of the case, and then I'll hand over to Fleur, who will speak for about 15 to 20 minutes, and then Stewart will take over for another 15 to 20 minutes, so we're going to leave some time for questions. We are recording the event, so this will be able to be heard on the ILA podcast. The Q&A will also be recorded, but if you would prefer for your segment, if you do ask a question, not to be reproduced in the recording, come and see me afterwards. Okay, so let me just start by mentioning how we got here, which from my perspective, having taught climate change law for over a decade here at the Melbourne Law School, is very exciting, because year after year we'd be talking about prospects for litigation internationally and whether we could get the International Court of Justice, the world's most important judicial organ, the primary judicial organ of the United Nations, to provide advice on these issues about climate obligations. We were very interested to do so because, as you would know, we've had the other mechanism for creating or interpreting obligations, which is the conferences of the parties of the UNFCCC, the United Nations Framework Convention on Climate Change, and then the Paris Agreement of 2015. And we saw over time this push to recognize the legal obligations that exist, but how they were constrained in the text of the treaties in many ways, including by an emphasis on the greenhouse gas emissions management, rather than obligations relating to fossil fuels, relating to human rights, relating to the protection of the oceans, which is an area of grave risk from climate change, and where law of the sea has a lot to contribute, and also from general international environmental law principles relating to transboundary harm and the duty of prevention. So we knew that there was all this law we knew that there was scope to provide better legal certainty about these laws, and it seemed like the UN ICJ was out of reach. Palau attempted to discuss this in the General Assembly over a decade ago, and it went nowhere. Then came Vanuatu. You might know the story of a group of students who kept pushing this along with state officials who'd been aware of the prospects for many years, as well as other officials across the Pacific. And finally, we came to a General Assembly vote on a resolution posing a question to the ICJ about the content of the obligations, but not only that, also about the legal consequences of those obligations. So a real landmark for legal prospects in addressing climate change. So the proceedings were heard in December last year, momentous legal proceedings which occurred at the ICJ in The Hague, but were also broadcast on UN Web TV. Many of us were glued to our screens at the very early hours here in Australia because the time zone wasn't friendly, but we couldn't stop watching. I mean, these were mesmerising proceedings, particularly from Vanuatu and the Melanesian Spearhead Group. Thank you, Fleur. And we were taken aback by not only the performative aspect of these individuals bringing their accounts of climate harms to the court, but also the substance of the legal claims which reproduced a lot of the legal material that we'd been considering in my class on climate change law, for example, but also some very innovative arguments surrounding self-determination, innovative arguments that I think the group within the Pacific had worked very hard on for many years, and which has really, I think, pushed the court. The court will be relying somewhat on a recent advisory opinion from the International Tribunal for the Law of the Sea, which was asked a similar question about legal obligations just within the UN Convention on the Law of the Sea, which has obligations of states to reduce, eliminate, control pollution. So the question for that tribunal is greenhouse gas emissions a pollutant under that convention? And the tribunal told us yes. So we know that the Law of the Sea Convention has these obligations that sit alongside the Paris Agreement and the UNFCCC. We expect that the ICJ will take up those views of its sibling tribunal, but we also expect that the ICJ will be able to go further and tell us a lot more about the legal consequences of such obligations. So electrifying moment for international law, for ILA, for the Melbourne Law School, and we're so delighted to have these very learned and experienced presenters give us their own perspectives on these issues. Fleur, I'll pass to you now. Thanks.
I also pay my respects to the Wiradjuri people and particularly to their elders and ancestors. And I just wanted to mention, I have two colleagues in the room from Blue Ocean Law, so Rohan and Autumn. They're incredible repository of knowledge about this case. They did a lot of the drafting on the submissions, 300 plus submissions for Vanuatu. Rohan drove a lot of that, and also Autumn with the Melanesian Spearhead Group. And I also travelled with Autumn to many of these places that I'm going to talk about. So obviously we use the term insurgency, and in many ways Vanuatu's submission was a very technical, technically correct, in my view, perspective on the legal obligations on states in relation to state responsibility. I'm not going to really talk about that, so you can read that massive kind of PhD plus for yourself, and you'll get a lot out of it. I'm going to talk about an insurgent aspect particularly, and so I'm reading a paper which I prepared, particularly of the Melanesian Spearhead Group submissions. So that insurgent aspect was to effectively and expressly characterise Melanesian people's culture as many different worlds and climate change as world-destroying in the oceanic context. Such a characterisation was essential to express to the ICJ what is at stake for Melanesian peoples. As MSG said in its oral statement, Melanesia is a tapestry of diverse peoples, each with their own rich cultures, languages, and traditions. We are place persons, which means we are the places, we are the landscapes, we are the waters, we are the soils, the stories, and we are the flora and fauna. We are the weather, the seasons, and the spirits of our ancestral territories. Yet now, across our sea of islands, anthropogenic climate change has imperiled our people's physical survival and ripped apart the integral relationships between people and place that grounds our very existence. Simply put, climate change has unravelled the fabric of our lives. You will see, when I discuss some of the testimony, that words emerge, the worlds emerge out of places. But I want to first ground the possibility of this characterisation of the many different worlds by providing three bases upon which our worlds in Oceania rest. And hopefully you know what Oceania means: Micronesia, Melanesia, and Polynesia. That separation is a European construct, but one that we also have now adhered to and as part of our identities. So first, it reflects the incredible density of distinct languages spoken across Melanesia and indeed the Greater Oceania. There is about 1,400 languages spoken in our region. This is about a third of the world's languages spoken by a tiny fraction of the world's population. Vanuatu, for example, is home to 138 languages, and Papua New Guinea is home to about 850 languages. I call these languages ecologically derived languages because they are derived or inspired by the places where people live, as well as corresponding to the density of biodiversity in the region. Linguists have discovered that language density in the region matches the density of biodiversity. Melanesia is referred to as a biodiversity hotspot, the whole of the Pacific is, holding about 10% of the world's biodiversity. We also referred to these languages as place-based, a term that was borrowed from Professor Jamon Halvards, to signal depth of these connections. As he said, it is hard to distinguish persons from places, and we got an expert report from him so that we could construct this argument. Secondly, the characterisation of worlds derives from this underlying unity or fabric between a person and a place in Melanesia, as with Greater Oceania. Because these languages are ecologically derived, they hold an immense and dense knowledge about that place. Some scientists have referred to this knowledge as stupefyingly rich. For example, a marine scientist who spoke to a Palauian master fisherman about reef fish said that he knew the lunar spawning cycles for several times as many species of fish as had been described in the scientific literature for the entire world. Thus, our worlds in Oceania are enormously dense and detailed. Thirdly, despite this underlying unity of people and place and other commonalities between Melanesian peoples, as each culture is place-based, it is this place-basedness and the uniqueness of each place which reveals a world. Fabrice Wolsey, a Kanak New Caledonian linguist that we spoke to, provided an expert report for the MSG. He uses the term cosmomorphism as opposed to anthropomorphism to explain the reflection of the world within the Kanak peoples. And he quotes an academic who points out the Kanak identities with the world, the Kanak identifies with the world around him, particularly the plant world. The world lives in him, is him. But I take the term cosmos further to express different relationships, philosophies, laws, identities, ontologies, spirituality, entire worlds, so to speak, in each place. This cosmos is reflected in MSG's interpretation of place persons as the indistinction between persons and soil, water, sea, etc. Samoans have a similar understanding of belonging, which we call whaasingamonga. As Tui Atua Tapua Tamasese Ta Esi Efe, one of Samoa's paramount chiefs puts it, we share a divinity with the cosmos. I share divinity with my ancestors, the land, the seas, and the skies. Or as Yulani Ampu, a Papua New Guinean marine scientist, said to me the other day about her relationship with the turtle, I am the turtle and she is me. I will now discuss some of the ways that the worlds are revealed in the testimonies before the court. There were 35 testimonies, and I could have done the same thing with any of them, but I'm focusing in particular on two places I visited, Yakau village on Tana Island, which I went with Autumn, and Verabai village in Papua New Guinea, which Stewart came on the last trip, and I've been there a couple of times. The yam in Yakau village on Tana Island in Vanuatu is more than a crop and more than food. He is an ancestor, one of the first humans to settle in Yakau. The yam is also known as the king of the crops and is the most important crop. Yakau is known as a custom village, which means that the people of Yakau have self-determined to live according to their way of life and traditions and have consciously rejected the adoption of Western ways. Kaubapin, their supreme god, created the yam and the other custom crops. They were given first the spirits. The spirits travelled around and sometimes took the shape of stones. When the yam and other custom crops arrived in Yakau, they took the shape of humans, the ancestors of the people living there today. These ancestors are known as tapunas, which is also a chiefly title and system. The tapunas today are the direct descendants of each custom crop, including the tapunas of the yam. As the king of the crops, the yam is featured in all important ceremonies in Yakau. One of the most important is the Naukau, which is a 4-day festival with dancing and feasting. And it includes what could be described as a political dance called the toka, by which the people of Yakau choose their highest chief. Mangau Ioke, a 78-year-old man from Yakau, gave testimony about the yam. He is what I would call a master gardener and a spiritual custodian of the yam. He is also the tapunas of the yam, which makes him a chief. Part of his chiefly responsibility to Yakau is to ensure an abundant harvest of yam and to ensure that the community can fulfill their many ceremonial obligations. As tapunas, Mangau is also the custodian of the stones, one of the forms that the yam took, which he uses to perform sacred and secret ceremonies. Mangau has been growing crops and yams all his life. You can say he is an expert on the yam and its many varieties. He went to the gardens with his parents as a child who taught him how to grow crops. They passed on the knowledge of the yam to him, how to grow it, when to grow it, and where to grow it. He took his children and now takes his grandchildren to the gardens to pass on the sacred and technical knowledge about the yam to them. But the yam has disappeared from Yakau. When Autumn and I took Mangau's testimony at the beginning of 2024, it had been 4 years since the yam had grew there. For years before that, the yam was already struggling. Each harvest was smaller and the yam was frequently rotting in the ground. Now, it does not grow in Yakau at all, despite Mangau's technical knowledge about soil, traditional fertilisation, seasonal timing, and growing the yam. Mangau has observed big changes to the weather over his lifetime. He credits changes in the rain and the heat to the yam's demise. The heavier rain in particular is causing the yam to shrink and die. Yams do not take too much rain. Yams do not like too much rain, but the rain that comes now is too much. The death of the yam has so many flow-on effects that it is impossible to cover them all here, but I will mention 4. First, it is fundamental to the community's self-governance and self-determination, including when they choose their high chief in the toka dance, as well as the chiefly power and authority that the yam bestows on Mangau. Mangau's status is undermined and the community can't perform the toka. Secondly, it affects their food sovereignty and security. The yam is one of the most complex foods in nutritional composition and is described in Western science as a biofunctional food. In Bislama, the Creole language of Vanuatu, they have a saying that the yam holds the stomach. It sustains the energy needed for dancing and ceremonies As Mangal said, it gives the community strength to dance for their 4-day ceremony. It's not just the yam. As some of the women in Yakal told us, most of the crops in Yakal are failing or are struggling. Added to this is the new intensity of cyclones, which were once part of their life cycle and an integrated part of their world, including by pruning trees, fruit trees. So they weren't afraid of cyclones before. They are now a destructive force, destroying trees, plants, their soil and gardens, and the heavier rains are causing landslides, especially to the lands already devastated by cyclones. The women have to walk for a whole day to get to their gardens, as the land near the village has been ruined. They walk down a mountain and across a ravine and walk up the other side. When they get there, they have little time to tend to the gardens before they have to walk back. It is back-breaking work, especially for the older women. They are hungry now and wish for their traditional abundance to come back. Tanna, after all, is known as the land of plenty and big soil, alluding to how fertile the soil is and the former abundance of food. Indeed, one of the other important ceremonies is the Neel, a ceremony of giving, where surplus crops were given to another family or village, which both strengthens relations as well as enhances the status of the gardener. The undermining and unravelling of food sovereignty and security is an issue for all communities across our Sea of Islands. When I was working on the Samoan submission, I couldn't stop looking at this one statistic they gave me, which is that the heat threshold for customary crops in the Pacific is 1 to 2 degrees. That's exceeded. It's exceeded. Thirdly, the planting and the harvesting of the yam is connected to cosmological cycles, including what we call nature in English, but which is a wholly inadequate and flat term in this context. Human and environmental cycles coincide and are fused. The Ora tribe of Kanaki, New Caledonia, and Autumn and I also went to New Caledonia together, Kanaki, who also gave evidence to the ICJ, talk about their seasonal calendar, which is tied to the cycle of life in their place. It tells them when to plant the yam, which is when the whales pass through their seas on the yearly migration. There is a whole genealogy and history about the connection between the whales and the yam. Weri Nara from Port Resolution in Tanna gave evidence that when they plant the yam, they stop fishing as it coincides with the fish breeding cycle. Lastly, this is the last major flow on. Mangal personally feels devastated, broken and empty. In his words, now that the yam has vanished, my heart is broken. My connection with the yam spirit is broken. Before, through my family and my ancestors, I was able to lean on the spirit when I needed it. But now I don't have anything to lean on. It just feels like empty space. Because the spirit is no longer there, I feel empty. I'm walking around like an empty shell. I feel that I've failed in my duty that has been passed down from my ancestors to my grandfathers to me. Mangal feels dead inside. Other people we gathered testimony from have used similar expressions and have characterised such losses as akin to death. If we return to the concept of cosmomorphism as the world or the environment living or reflected in a person, is in a person, then we can think of the loss of the yam for Mangal and its emptiness also in this way. It is the loss of the yam within him. A loss he deeply feels is empty space. Indeed, Mangal notes that some of the varieties of yam are the names given to men in Yakal. This is because the yam is inseparable from us. It is our identity. That's his words. Mangal also worries about the other crops. In his words, now that the yam has disappeared, the spirit is telling me that the other crops will disappear in the near future too. Weri, who is also a master gardener of the banana in Port Resolution on Tanna, feels similarly, in a similar way. Some varieties of banana stopped growing 7 years ago. He said, I believe that we are seeing the slow collapse of our gardens. We live close to the land. We know when things are not well. The banana for Weri is linked with the origin of living and the origin of the place that he lives in. It's connected to how the seas were formed. It's got this incredible story. The banana and the other crops were brought into existence by the birds and other living creatures, and the stories of these origins also provide them with the model of how they live. The banana is not just a banana. It cannot be replaced or bought or substituted with a new type of crop, such as in a climate adaptation program. Mangau is upfront about this. I can't go get yams from another place to use in custom ceremonies. It wouldn't be connected to our place or our spirits. For the people of Verabai village in the Kakori Delta in Papua New Guinea, even death can't get close to explaining the prospect of losing their lands to the now rapid and violent sea level rise they are experiencing. They've moved already 4 times and are contemplating their final move, as there is no further land to go. I travelled there twice, 7 months apart, and the rapidity of the sea rise shocked me, as the place I stayed in was destroyed between 2 trips, and I'll show a picture of this place I stayed in. Unlike the other tribes in the area who have migration stories of how they came to live on their lands, the people of Verabai originate there. As Julian Argan, my colleague and the founder of Blue Ocean Law says, they are the custodians of one of the birthplaces of humanity. As Ara Korel, their community leader, said, "We originate here, we were created here, we are from here. This is our only home, we cannot leave." The testimonies shaped the contest in the ICJ between an insurgent Oceania led by Vanuatu and MSG and the fossil fuels states. These testimonies and the way that they were utilised brought the voices of the climate dispossessed into the courtroom and indeed the reality of climate dispossession itself. The testimonies expressed what is at stake for us in Oceania, the loss of worlds, plural. Climate change is a cosmos killer. The people of Verabai are not being displaced, they are being dispossessed of their cosmological origins, their world, their lands, and their custodianship of a place of humanity. Mangau and the people of Yakal have not just lost their food. Climate change has severed their connection with their ancestors, emptied their selves, undermined their self-determination, and is unravelling the fabric of their lives and the fabric of life itself. It is irreplaceable. As Samoa said in its oral submissions, Samoa emphasises the practical importance of immediate cessation of wrongdoing. Reparation, whilst important, will not assure our survival. This is also our survival as a peoples with distinct identities. In other words, our collective or existential identities. The testimonies animated the detail of the legal submissions and put in front of the ICJ the unmistakable violence of climate change across our Sea of Islands and on Melanesian peoples, as told as closely as possible through their indigenous reference. Just over 30 years ago, and I'm not sure if there's any islanders here, but every islander who's an academic knows, Ipeli Hauofa wrote the seminal piece, Our Sea of Islands, which remains the touchstone for thinking about Oceania. At the time, he was writing against our consignment to smallness, which was used to belittle and denigrate us by the great powers, including as too small to be sovereign, self-determining, self-governing. Instead, Hauofa reminded us of our historical interactions, our epic navigational histories, our connectedness. Oceania is vast, Oceania is expanding, he told us. He said we must be defined not by the smallness of our islands, but by the largeness of our ocean, which covers 1/3 of the globe, the Pacific. Many Pacific island states referred to themselves as big ocean states, or our region as the blue continent before the ICJ. But such an expansive notion is, I would argue, matched by the depth of our places, the depth of our relationships with and knowledge of those places, and the distinct poetic languages derived from them. These are worlds, 1,400 micro-worlds. Worlds matter. Perhaps it is time to refer to Oceania not as our Sea of Islands, but our Sea of Worlds. That's it. So this is Yakal village. So when Autumn and I went, they performed a dance for us, and we were also dressed up to jump in and start dancing with them afterwards, just to build some trust. This is us taking some testimony, and this is in the Bislama, it's called the Nakamal. This is their kind of parliament, spiritual house, community gathering place, which is surrounded by massive banyan trees. This is Mangal, and Autumn took this amazing photo. That's me, Autumn took, of taking Mangal's testimony. We took testimony in very interesting places, including this place. And community would come and watch and support. We went with the Attorney General of Vanuatu. We also spoke and made sure that we got women's testimony as well. And so we took them away from the village to get their testimony, and this is us doing so. Because it was an advisory opinion, we knew that our evidence wasn't going to be contested. We did evidence in a way that we thought would probably be challenged in another court room, but we took collective statements. And I think that was a really important kind of innovation that Autumn and I did. This is on our way to Verabai. I could tell you a whole story about everything falling in place in terms of the funding and everything, but we had a very short amount of time to get this testimony. Like, we got Mangal's testimony. If you read it, it's beautiful testimony, but that should have taken us a month. So it was really like we did it, in a day and a half. It was really difficult to get the stories and to understand. It took a lot of skill, I think, to be able to understand this stuff in a very short amount of time. This is the Verabai village welcoming us back the second time, kind of realising the importance of the ICJ for them, and so they really welcomed us to talk to them. This is, the whole village was there. You can see the ruins of their place. They used to have, trees which were sacred trees, which separated them from the sea, and the sea is it's taking everything. They've got no electricity. They have not contributed at all to the crisis, and yet the sea level rise shocked me, because it's not slow anymore. Slow violence out the window. This is rapid and in your face. And you can see I stayed in this place the first time. It did scare me, because when I stayed there, it would shake because the sea would hit the building. And you can see what they got from the state was these bags to try and stop the sea level rise. There's no one helping them. And that's that building now. That's Mr. Ara and his wife standing in front of it. They've now moved to the back, and they don't have much land to go to. This is their place where their origin is from as a people. And that's us, the team, the Blue Ocean Law team. Thank you.
Great. Right, well, thanks so much. I'd like to also begin by acknowledging that we're on the unceded land of the Wurundjeri people, and I pay respects to their elders, past, present, and future. I also want to begin by thanking Margaret and Sandhya for being so gracious in very quickly organising this panel, and also to you, Fleur, for being just incredible. I feel emotional listening to your paper. It's just the incredible work that you've been doing, and the huge cost at which that's been done. Margaret referred to how we were glued to the UN news, and I'm going to keep my comments extremely short so we can have opportunity to discuss it. And from Samoa's submissions that Fleur and I have talked about, it was a moment when Samoa addresses in the oral submissions to the ICJ and points out that Samoa's police don't carry arms. And in Samoa, in other words, they rely on the rule of law with a very different conception of force. And it was an attempt to call on the ICJ to bring, all of the law that Margaret was referring to at the beginning to bear on fossil fuel sponsoring states. And that reminded me of another insurgent lawyer back in 1963, who was Nelson Mandela, who was addressing the court at the Rivonia trial. And I had the privilege many years later, obviously, of meeting some of his lawyers who had advised him not to make this statement at the Rivonia trial, where he was facing the death penalty. And he addressed the court and he said, I stand for the law. I am the rule of law. And that was in his final sort of statement to the court. And so when I was hearing and seeing some of his submissions and the submissions of other small island developing countries, I was really reminded of the force of law that these countries are actually bringing to bear. And the second vignette is of Veribari, which I had the privilege again to visit last October with Fleur. And as she was saying, it's a village of 1,000 people, hundreds of children whose school's been destroyed 3 times and they don't have a school any longer. And the point about the cosmology or the cosmomorphism that Fleur was talking about is that if the trees, as is the case in Veribari, are an absolutely central part of the cosmological world, and the trees disappear, as Watna Mori, your colleague, put to us in the podcast that I've done with Fleur and Watna, the cosmology just becomes a story. It ceases to be an interaction with the world. It becomes a series of stories and myths and folklore. And what we're observing in the destruction of the trees, in the destruction of what people call biodiversity, but is obviously a far richer way of interacting with these people's surroundings, is precisely that destruction of world. So with the help of these extraordinary kind of observations and work, I've been thinking about it in relation to climate litigation. And in this paper, which is forthcoming next month, I've worked through a set of questions and analytics, not through the ICJ case, but I think what I'm going to try and do in the brief amount of time I have is to connect it to the ICJ case. But I've worked through several distinctions, thinking about what is, firstly, matter in the context of climate litigation, but is also a critique to look at what is the matter with climate litigation. And many of you will know the Australian Federal Court case of Sharma versus Minister for the Environment, and the absolutely serious missed opportunity of the full federal court to give a much stronger decision in relation to novel torts that might apply to climate destruction and in that case, the expansion of a coal mine. And quite a lot turned on, could I have the flicker, please? Quite a lot in the Sharma case turned on the fact that the full federal court found that it was not a matter of law on the basis of a very narrow interpretation, articulation of the separation of powers. And also there was a longer discussion about issues of causation, et cetera. And so I'm interested in 3 distinctions, if I can just outline them in the context of climate litigation. One is between this notion of a matter of law and matter in law. And I read Sharma and other climate cases, I think this applies in relation to the ICJ as well, as on the one hand, this question of jurisdiction, which pertains to a matter of law, and on the other hand, the fact that matter is in law in the sense of greenhouse gases and the consequences of fossil fuel emissions being brought into the court. And I think I'm not going to have time to go through all of these slides, and Margaret's referred to some of them. But in terms of, matter, I've just flicked through too much there. Where have I got to? Sorry, obviously not so good at flickering. I'm going backwards. Sorry about that. In the context of the ICJ, the matter of law is the question of what law should apply. And you will all probably know the argument is between whether the UNFCCC, thank you, that's the place I need, that's the one, thank you. And it's presumably the big arrow that I use. Anyway, I'll figure it out. Obviously really high tech with my little notebook here. The matter of law here is the question of jurisdiction, about whether it's UNFCCC or the entire corpus of international law that Margaret was referring to, that should apply in the context of climate change. And the submissions, as Fleur pointed out, are incredibly detailed in terms of all of the legal regimes that ought to apply apart from UNFCCC and the Paris framework. Now, in terms of matter in law, I think this material that was presented and the science is very clear on how responsibility can be attributed to particular countries and who can be held responsible. And in this slide, you can see the sort of top 10 countries in terms of greenhouse gas emissions. So I'm just gonna race along here in terms of my analytic on this. So there's a tension between matter of law and matter in law, and how the courts will arrive at that, and maybe we can talk about that a little later. There's also a body of work that treats law as matter. And I'm thinking here of Bruno Latour, Jan Thomas, the Roman law theorist of Roman law, and Alain Pottage, who treat legal forms such as tort, but one can also think here of all kinds of regimes of international norms as and its form as the matter. And so this has been incredibly influential, I think, in legal thinking. And so part of what I do in the paper, What is the Matter with Climate Litigation, is to point out how, while I can see the critiques on legal personhood, for example, that Jan Thomas and influenced by him, Alain Pottage have been making, I'm incredibly suspicious of the political and social neutrality with which legal forms are treated by that entire body of work. So Jan Thomas himself was incredibly conservative, for example, on gender and kinship issues. If you read the original essays, the suspicion about expanding legal personhood was mostly, based on the fact that it is an ideological set of reasons that lead to legal personality being expanded. So there is this kind of, I think, very influential body of work, and I think Kathleen and others have also been working with, for example, Margaret Davies's work of how the notion of matter itself can be hugely expanded, and matter can carry norms in its own right. So I take this kind of tripartite sense of matter and feed it through dialectical thinking of Theodor Adorno. And I'm sorry, this is not enough time to really kind of do that in any kind of detail, but just to sort of very briefly set it out. Adorno's thinking in negative dialectics was to theorize the way in which the marginalized in a universal history can be preserved, that is preserved, that a negated category in a dialectic isn't completely destroyed, right? So when, for example, Fleur is talking about the marginalized knowledges, the cosmologies, the negated in a otherwise seemingly universal account of the human is presenting itself, and even when it gets negated by courts, which may well happen. I mean, you're maybe a bit more optimistic about the ICJ than I am, and I hope you're right. The negated preserves itself. And the old example of this, of course, is what's happened in the context of colonialism. The Haitian Revolution is often referred to as an example of who was left out of the universal and how those left out returned and made this return. Now, my overall argument in the paper is that law functions to mediate this dialectic between the universalizing drive of the human in its Western instantiation and the communities and knowledges that are negated in that universal process. Adorno himself, I think, was very attuned to this. I mean, his early writings on this was as early as 1931 in a lecture. He spoke about the catastrophic character of modernity in his book with Horkheimer in 1944, and then in his lectures on history in the 1960s. So that's the material that I try to draw on to engage with what I see happening in the context of climate litigation. But in order to have some discussion, I'll stop there. Thanks.
Thank you very much, and thank you for the great question. I want to add 2 cents, which is one of the findings from the ARC Discovery Project study that Hilary Charlesworth and I conducted, was that these advisory opinions can have latent effects, powerful effects years later, as we saw in the Western Sahara advisory opinion that was cited by a high court in Mabo. So I remain convinced that, you know, even these harrowing testimonials, which we saw in the nuclear weapons advisory opinions, can come back and are now on the record. I also wanted to mention that something came up on legal personhood, and there's a segue to mention the ILA podcast recording from yesterday's book launch of Anna Arstine Kerslake's new book on legal personhood and marginalised groups. We had Helene Lambert, Erin O'Donnell and Olivia Barr talking about that book yesterday, so please cross-reference to that if you didn't make it yesterday. Couldn't resist that advertisement for ILA, but I think it caps nicely some of the themes that were raised today and how this is an ongoing conversation, and that we hope the panellists will stay with us and keep discussing these issues with us. Thank you.